All right. Do we know if Mr. Gilner is he going to be connecting through the jail?
He should be, Your Honor. He is lodged. I spoke to him a little bit ago in the jail.
Okay. I am just waiting for them to connect, so if everybody can just stay on the line, as soon as I see them, we'll get started.
This is Heather. Hi, Diane. Oh, great. That be forward.
All right, Mr. Gilner, are you there?
Yes, sir.
All right. Are you seated right now? Can you stand up? Because all I can see is the top of your head and the camera there. There we go. All right. Thank you.
Hi.
Thank you. And just for the record, your name is Stephen Gilner, is that correct?
Stephen Michael Gilner.
Okay, so we'll go on the record now in People versus Stephen Gilner. This is file number, Crawford County District Court file number 2518080-FY-1. I'm conducting this hearing today on behalf of Judge Burmeister. Mr. Gilner, you're before the court today for an arraignment on 3 different felony charges. I need to go through a few things with you with regard to your rights as well as those charges. So first of all, I want to make sure that you understand the charges and the maximum possible penalty. You're charged at count 1 with second-degree arson that alleges that on or about June 23rd of 2025, you did willfully or maliciously burn, damage, or destroy by fire or explosive a dwelling or its contents. That is a felony that carries with it maximum possible penalty of up to 20 years and or a $20,000 fine or 3 times the value of the property. Do you understand that?
Yeah, sir.
At count 2, you're charged with intimidating a witness. That alleges that on or about June 23rd of 2025, that you did willfully impede, interfere with, prevent, or obstruct, or attempt to willfully impede, interfere with, or prevent or obstruct the ability of a witness to attend, testify, or provide information in or for an official proceeding by threatening to kill or injure that person. That is a felony that carries with it a maximum possible penalty of up to 15 years and or a $25,000 fine, and could subject you to consecutive sentencing if you're convicted of any other crime along with that. Do you understand that?
Yes, sir.
And then finally, count 3, bringing a weapon into a jail. It alleges that on or about June 23rd of 2025, you did bring into a jail or a building pertinent to a jail a pocket knife, and that is a felony that carries with it a maximum penalty of up to 5 years and or a $1,000 fine. Do you understand that?
Yes, sir.
All right, you do have the right to have an attorney present in any subsequent proceedings. If you can't afford an attorney, one would be appointed for you at public expense. Mr. Thompson is present here today for purposes of arraignment. Did you want to see if you qualify for a court-appointed attorney, or did you want to hire your own attorney?
I'll take a court appointed. I don't have the money.
Your Honor, I did screen Mr. Gildner. He has been approved for court-appointed counsel. I will be appointed as his attorney.
Okay. All right, and then the court will set this for, I'm sorry, Mr. Thompson, then does Mr. Gildner want to enter not guilty pleas today, or how does he want to?
Yes, we'd waive a formal reading as to the not guilty plea be entered on his behalf. We are requesting that the preliminary exam be scheduled within 21 days in this matter. Thank you.
Okay, so the court will enter not guilty pleas on behalf of Mr. Gildner. The court will set this, right now it's set for preliminary exam to occur on July 29th, but you're asking that to be set within the 21 days, Mr. Thompson?
That is our request, yes.
Okay, so we'll have to get that properly scheduled in front of Judge Burmeister. And then in terms of bond pending the next hearing, Ms. Cope, do people take any position with regard to bond?
Your Honor, I'm going to ask for a high cash bond, and should he be able to meet that bond, a no contact order with Miss Jody Gay. Mr. Gildner has a very long criminal history. We've dealt with him numerous times in our office. Law enforcement deals with him all the time for substance abuse issues. The chance of conviction, I think, is high. Frankly, he admitted it in front of the police officer that he was going to burn it down. It was a home. He told Miss Gay that if she were to testify against him, he would kill her. He took a pocket knife into the jail. Those are the allegations. His criminal history involves a 1982 burglary. It doesn't have the segment because it's old. 1990 felony assault with a dangerous weapon, OWI. 1997 OWI. 2012 felon in possession of a firearm. 2014 allowing DWLS. 2018 felony assault with a dangerous weapon. He had another assault dismissed as part of that plea, a possession of meth case in 2022, and I think 2 separate disorderly cases in 2023. I think it is a risk to both himself and the community to allow him out, and I would ask for, again, a high cash bond given his criminal history and the allegations and chance of conviction. Thank you.
Thank you, Mr. Thompson.
Your Honor, we understand these are serious allegations and that there's going to be a cash bond. Would ask the court to note that Mr. Gildner has long-standing ties to the community. He's been a resident for some time. He has family in the area. I believe he has some failures to appear, but he does ultimately show up for court. I'd ask the court to take all that into consideration, suggest a $25,000 cash bond. Thank you.
All right, looking at Mr. Gildner's prior history, the court does have concerns regarding public safety. He has been convicted of numerous assaultive offenses in the past, as well as offenses involving weapons. Looking at the seriousness of the charges in this case, as a 4th habitual offender, Mr. Gildner could be subject to up to life in prison on at least 2 of the counts here. So there's a high maximum possible penalty here. The court also recognizes that, again, the arson charge here involves allegations of destruction of property, and then the intimidating a witness charge. Again, the court has serious concerns with regard to that in terms of public safety, as well as Mr. Gildner's future appearance. So for all those reasons, the court finds that a high cash bond would be appropriate in this case. The court will set bond in the amount of $75,000 cash. And then the court will have to, through the district court, will have to generate a new notice of hearing in order to get this scheduled in compliance with the time limits under, by statute and court rule for the preliminary exam. So, Mr. Thompson and Mr. Gilner, the district court will get you, next dates. Do you have those right now by any chance?
What's that?
With
The judge
With
wasn't
the court
talking to you, Steve.
schedule,
You
it
can
would
let the
have-
clerk talk.
the court schedule, it would have to be July 1st for the preliminary and then, or for the probable, and then, the preliminary on the 15th.
Okay. So we'll generate a new notice of hearing that reflects those dates. Ms. Koch, anything else that we need to address for the record today?
If he is released, I would ask again for the no contact order with Miss Jody Gay.
So those have been, whether he's released or not, that is going to be part of the bond conditions as well.
Thank you.
So that is in there. Thank you. Mr. Thompson, anything further from your side today?
Nothing further from my side. Thank you.
Thank you. That's all for this hearing, and all parties are free to disconnect at this time.